Okay, I'm asking the customs guys to put up the feedback form, QR. I want everybody to take out their cell phones and take a picture of that. Everybody take a picture. I will make sure. I will compare my notes and the attendance list with those numbers of turned in feedback forms. Don't make me come to your office and get the feedback information. Okay, so as you guys are doing that, let me introduce our next speaker. We're gonna hear about the Japanese control of intangible transfer of technology. And we're gonna have Mr. Kiyoki-san come up again. Think of this as IP protection. Think of this as protecting your company's assets because it's that important. Okay, sir.
Thank you, Scott. Thank you so much. So, allow me to take the floor for the third time, and I think many of you are already fed up in looking at my face, but please allow me. So I will talk a bit about how Japan is tackling on intangible technology transfer issues. That means how we are encouraging universities or research institutes to properly control intangible transfer of technology. I have one word that ITT is not special. It's not completely separate from the export control. You may recall that the list of goods and technologies, it says goods and technologies. So in that regard, technology which is related to the development, production, and use of controlled goods are also controlled according to international export regime controls agreements, and which is also controlled in many cases according to each domestic laws and regulations. This one. And my presentation is mainly targeted to universities and research institutes, how we are going on an outreach to these universities and research institutes regarding ITT control. But I would like to say that many of the elements that I am going to present also have a lot of connections with companies, manufacturing companies, etc. So maybe you can take something out in order to think about when dealing with this complex ITT controls. And just remember, you may recall I think it's my first presentation, opening remarks, that I just told about the complexity of proliferators to acquire sensitive technologies, the methods or skills by which the proliferators are acquiring technology is becoming more and more complex. And it's not just an ordinary traditional export control that should be taken care of, but also this ITT, academia, and investment screening, etc., etc. And I just touched upon investment screening. Now it's the turn of ITT. And actually there is a recent movement for these 4 or 5 years that some of the concerned countries or concerned entities, they are trying to make use of this university joint researchers by sending students or sending professors, which are actually linked to the illegal entities or military entities. So that eventually justifies how it is going to be very important for the universities to properly control it. And this table actually shows how METI is providing a package, a policy package, in order to encourage universities to take ITT measures properly. There are, in total, 5 policy packages, starting from guidance for academia. This we've just issued a guidance paper for academia in order for the academia to take a reference on how they can introduce some institutional settings and how can they implement a proper ITT control on sensitive technologies. I think this is a backbone of a guidance paper. And we also have e-learning contents, which we just established last year for self-learning in order to be aware of what's the point, why we do have to control ITT, etc. And we also are trying to build networks among research institutes and universities so that there could be synergies. And also, the guidance is just a guidance, so it's sometimes difficult for the universities to set up an export or sensitive technology control system within their universities by just reading the guidance. So what is necessary is an expert. So there, METI created a expert dispatching expert advisors to each university so that this expert can analyze the situation of each universities and then give a kind of appropriate advice. And there is also an on-site consultation services provided by METI. I just told that METI has a strategic export control related personnel, about 120, 130. And there is a specialized staff, my colleague staff, made up of 5 people, which is concentrated on university ITT issues. So they are frequently visiting universities in order to provide an on-site consultation or whether to check whether universities are properly implementing this ITT control. So I just want to have a bit of a dig into what is the guidance paper, which is issued in 2017, which is almost two or 3 years ago. It's made up of several elements. And if you see the orange part at the left, the guidance paper actually refers to, so what kind of activity should universities have to take care of. And eventually, as it's written here, admission and exit of foreign students, they have to take care of that to be sure whether there is where a malintent is, there is no malintent in certain students. I think the case is very small, but maybe you have to take that into consideration. And the next is participation in international conferences. This should be a kind of, please take care about when you participate in international conferences, because there are an awful lot of presentations being done. And many researchers and professors tend to think, oh, it's an international conference, so there is an awful lot of presentation. And the fact that if you attend in international conferences and make presentations, that is our freedom on which subject we should present, etc. And that's basically true. However, there is a misperception that every theme which is going to be presented is a kind of a public. So no matter how sensitive it is, when it's a piece of PowerPoint, you're free to do it. And that's not true. You have to take care that some of the international conferences are very limited in audience. It's limited to some researchers, it might be, and some of the themes of this presentation includes such materials which is not intended for publication. So, but many of the universities don't take care of those. That is the activities which should be taken care of. And of course, visiting fellows from overseas. This is just the same as admission and exit of foreign students. This is kind of activity-based. And the guidance paper also cites what is the critical research areas that you should take care of. And in that regard, this guidance paper includes 55 critical research areas that universities should pay particular attention to. And why we issue 55 research areas? Is it an addition to normal export control? The answer is no, because all the export management, export control is based on the laws and regulations, and it is just the same as goods. The reason for this is that many universities are not familiar to strategic export laws and regulations. So if you tell universities, so please check laws and regulations and see if your research activities are controlled. But some of them doesn't really understand because it's sometimes so complicated. But when you show 55 areas like nuclear engineering, automatic control, robotics, aerospace engineering, as kind of a guidance that you have to be careful. And it doesn't mean that these are controlled, because some of them are controlled, some of them are not. But the point is that we have to interpret so that professors and students will understand what are the fields that you should be careful about. And then, if you dig in, the next step is to see the laws and regulations and then to judge whether a certain, for example, nuclear engineering. Not all nuclear engineering is controlled, but it's a kind of a first start, to show the first start. That's the intention of this publishing 55 critical technology areas. So, and at the green part, we have a control methodology. And so this tells you that, for example, a top-down system led by this university rectors or president to be responsible for that university's export and sensitive technology control, and to establish security export control division inside the universities. And I heard from the previous session about how it's important for the companies to be aware and to be committed to export control. And this is just the same. So in organizational point of view, a president of number one who leads university or research institute should be committed to export control. In this case, so the main theme is technology transfer. So they should be aware of how this technology control should be done. So this guidance paper tells you from the organizational point of view to that the president should be responsible, and export control division or technology transfer division, in order to scrutinize or screening the technology, should be established. And division of roles, which is written here. And lastly, the model documents. This is a guidance for universities to show what is the example of internal compliance program, etc. Sorry. So this is so far what METI had been doing in order to encourage universities. And thanks to our outreach, the targeted university, almost half of the targeted universities introduced export control or sensitive technology control system within their universities. And it's a very good news. So maybe I can finish my presentation here, but I cannot finish my presentation here. Why? Because I said they established that system. But what is the reality? Do they actually utilize that kind of system? Are they really workable, functioning? The answer is, unfortunately, no. Many of them established, but many failed, or I may not use the word failed, but it's not sometimes properly functioning. And that is a role I will get into, I just go back to here. That is the reason why we conduct on-site consultation to each universities in order to find out what is the problem. And actually we found out a few cases in which some of the projects, they are actually not going through the export control section of that universities and causing a problem. So the role of METI or etc. is to make sure whether the ITT control system, which has been established, is properly functioned, in addition to encouraging universities who hasn't yet introduced such a system. Now, talking about further actions, well, I've just talked about the research institutes and universities per se. And as you know, or you might know, many of the universities rely on government funding in order to carry out their research projects. So the important thing is that those institutes which provide funds to Japanese universities should also be aware of ITT control. I just cited NEDO. Maybe this is not familiar to you, but it's New Energy Development Organization, which is affiliated to METI. And that's actually a funding agency which provide funds to universities in order to carry out the new energy studies, etc. And in addition to the universities per se, if this funding agency is well aware of this ITT control, that would be very beneficial. And further actions is to make sure that all the funding agency in Japan apply ITT control per se. Now it's METI related, but many of the funds are provided through institutions which is under Ministry of Education. So I think that is many discussions are going on in order to broaden the scope of this. And I've talked about this guidance paper, and there's an interesting addition to this. Actually, we compiled 40 near-miss cases in universities. What is near-miss cases? These are the cases in where universities are about to malfunction. And so if we present these kind of malfunction cases, it should provide a good example to universities. We should take lessons not to do that, to improve ourselves. And there are 40 cases. Unfortunately, many of them are in Japanese still, and we are trying to translate in English. However, I've just picked up successfully 6 or 7 cases of that, so that I can just introduce as an example. The first case is the content of misconduct is that a certain researcher actually in the university consulted a section inside of that institution in charge of export control in order to confirm whether the technology to be transferred is subject to export control, subject to Japanese export control or not. And this researcher initially self-determined that it was the technology is not controlled. But when he took it up to the export control section, it was found out that, well, this technology was actually under control. And the misconduct is that this researcher was referring to old laws and regulations. And I think there was some mentioning about you have to refer always to new, the latest version of latest update of laws and regulations, because it is yearly changing. So there is a possibility that some of the technologies which are not previously controlled is newly controlled. So this is one of the lessons to be learned. Now the second example is that a certain professor was asked by another professor abroad to send him a kind of a goods. So the foreign professor wanted to ask this professor inside Japan, please send me a kind of an equipment or device. And they were, in fact, they were friends. So that's the reason why this foreign professor asked this Japanese professor. Now, this happened that this foreign professor in the foreign university, foreign university happened to be listed in the foreign users list. By the way, Japan is publishing a foreign users list, an end user, which has concerns in terms of developing weapons of mass destruction and others. Of course, I just like to mention that this foreign user list does not automatically mean that it's banned for export. It's just a reference for the exporters to judge, to be careful about. So some of the exporters may deny it automatically, but it's not necessarily the case in terms of kind of a laws and regulation point of view. However, the lessons learned from here is that, okay, this foreign university happened to be listed in foreign users list. However, if it's not listed, if it was not listed in the foreign user list, what happened? This professor, Japanese professor, might have exported these goods to his friend, professor overseas. But the fact that whether it is not included in the foreign user list or other kind of a chaser list or concerned list, of course that's very important. But even if a certain entity is not listed in a kind of a warning list, it does not justify that, everyone who is not listed, it's free, that's safe. That's not true. So you should be careful in determining whether that is appropriate or not through checking or through identifying or capturing a red flag or signals. So that's lesson to be learned. So the third case goes into a public domain issues that, yes, there's a professor who consulted the export control section that, the research result to be presented at international conferences held in other country will be regarded as a public release of technology. And it happened that yes, so in this case, it was found out that the presentation material is not a disclosed one. and the materials were confidential, and the participants are very confined. And this is one of the most interesting or most concerned case, because I will repeat once again that whenever a researcher or professor attends international conference, there is a tendency that, okay, this is just a presentation material, so it might belong to a public domain. And actually, I think many of the people here understand that technology in the public domain, which is already published, is decontrolled. It's not under control. But what this lessons learned is how people interpret technologies in public domain. This is a very, very difficult issue to learn. And as in this case, many of the professors tend to think that, okay, all the presentations should be in the public domain, which is not the case. And this lesson could also be applied to companies and other manufacturing companies which tend to have certain exchange of information on a presentation basis to a customer, etc. And this is also a history, a case in which where students, when receiving overseas students, that it happens that the student was actually studying in a very short term in an overseas university which was listed in foreign users list. And it was later found out after accepting that student. And after investigations were made, it was found out that even this student was actually studying in this foreign universities, which is in the foreign users list. His study theme had nothing to do with this control technology. And the result was, there was no particular problem. But the lessons learned is that before accepting a student, there should be a kind of a screening for that student. And this is a bit of a tricky one, but many of the projects, joint projects, there are contracts. But some of the projects are not having contracts because the money or financial settings has not been completed. Even in that case, there are cases in which actual project is starting. So in that case, no checkings are made, etc. So it should be a post-investigation. So lessons learned is that you should have a kind of a contract in every instances, or even when you don't have a contract, there are cases that you start the actual project. And in that case, universities should have a certain mechanism in which the screening of the transfer of technology should be conducted. So I have, of course, 35 other cases which is on the course of a translation into English. I think I will have a chance to soon to introduce that also. But, these are some cases. In any case, ITT Control encouraging universities is not an easy task. One of the problems in administrative government point of view is that industries, private sectors, manufacturers, they fall under the jurisdiction of Ministry of Commerce, Ministry of Trade. In the case of Japan, many of the manufacturers, they fall under the jurisdiction of METI. However, universities are not under the jurisdiction. It's jurisdiction under Ministry of Education. Sometimes this I'm a government official, but I have to admit that if the jurisdiction is different, things don't go well. So what is important is collaboration among different ministries, because it's not just Yeah, you take care of this, you take care of this. But as I just mentioned before, it's proliferation and export control is not just a matter of one ministry or it's a kind of a whole of the government approach. Something must do about this. In the case of Japan, it took about 4 or 5 years for METI and Ministry of Education to collaborate. Now we're in a very good relationship. And now, the other one is that in addition to this bottom-up approach, a top-down approach is necessary in order to bind together all the administrative forces into one. And in order to do that, a very high level should understand the significance of controlling a sensitive technology so that it's not used for WMD development or etc. And thank you very much, and I will take questions. Thanks.
We have one question.
Okay.
I think that this.
Yeah.
So, okay. Yeah, just so we know, just due to time constraints, so we can get, we do have a hard stop at 5 o'clock. We'll take the one question, and then I'm sure there'll be time on our way out if there's secondary questions. So please.
Hi, Mr. Joji. Thank you for your presentation. We have some problems I would see, not just me from my company, but also from the other industry players, that we may have some problems in getting the universities and the research institutes or even the government to sign certain contracts with us, incorporating export control clauses. So what kind of advice would you give when we face this kind of situations and we cannot get them to sign our clauses? How do we protect that that this happens? When this happens, what are the recourse that we have, for example?
Thank you. I think that depends. I don't know the background of that, the difficulty of having a contract, because sometimes it arises from the universities which are trying to, to provide certain technologies. And there are some cases that this universities who are providing technology is well aware of this, this control, and some are under control. So one case that I know is that this university is requesting the partners that the technology transfers should be used in particular cases and not to be retransferred in any case, and there should be some monitoring. But in that case, it should be the responsibility of the accepting parties to abide by as much as possible. But having said that, I am not really sure if that's the case. There might be other cases.
We're gonna, because of our time, we're gonna ask that any questions be, after the event as we're leaving. Unfortunately, we do have a hard stop at 5 o'clock, and we still have 2 more presentations, of which are pretty important. So, sir, thank you so much for your time.
Thank you.
We really appreciate it. Okay, now let me introduce Johnny Chia from FTI Consulting. He's going to give us a breakdown on the Chinese export controls. I know that I'm interested in this one because I think this is kind of an enigma out there, trying to figure out what's really happening.
Thank you. Well, because I saw many of the speakers, they do the survey. So here, I would like to exercise this privilege to do a survey as well. Please let me know how many of you have ever heard about the introduction to China's export control system? Okay, good. And by a real Chinese? No. Okay. Well, first I would like to do some self-introduction. My name is Johnny Xie. I'm based in Shanghai, a managing director of FTI Consulting. FTI stands for Forensic Investigation International. So we are the guys good at the forensic investigation, corporate finance, etc. So to some extent, to echo the concern or issues mentioned by our previous speakers regarding to find out or dig out the background regarding some end users or end use. That is what we do, but not on a transaction level. We do that for example, like IPO, you want to go public, you want to screen out all the risks, or you want to do merger and acquisition, want to find out partners, all kinds of risks there. So we can help do that kind of investigation very thoroughly, including export controls as well, but also many other areas. And personally, I served China customs for 11 years, and following that, another 11 years in consulting and the training industry. I'm also an accredited trainer of the WCO World Customs Organization. So today, I would like to share my some insights and understanding of China's export control system with you. First of all, I'm going to talk very briefly about the history of China's export control evolution. Because of time, I just want to mention that the rule of law, because the export controls or strategic controls are part of it. If you compare this diagram with the trends of China's GDP growth, you will find that after the 2000 onward, before that, China's GDP growth is like this way. After that, it's like this way. They're really changing from a linear growth to an exponential growth. So what China has done during that period, we exceeded the WCO, but on condition that we have to prove ourselves as a market economy. So we have to systematically to re-engineer, to reformat all kinds of legislations. And among that, many of them are pertaining to export controls and sanctions. So those are the information you can check by yourself. And some recent development. This I have noticed very significant change there, especially for this new Chinese administration. We know President Xi took the leadership in 2013, and then following that year in 2014, China presented its Belt and Road Initiative. So this is for the first time that Beijing would like to systematically to approach, to reach out to the rest of the world, to making more collaboration, to making more business throughout the world. So within that framework, export controls and our compliance performance culture will be a key over there. And then following that year in 2015, China also introduced its national security law, within which we took the economic interests and our capacity to defend that interest as a concern of our national security. So that is quite similar to US legislation. If you read out the EAR, many of the reasons, for example, adding somebody into the entity list, it is because of the contrary to their national interest or their foreign policy, etc. So China is learning quickly that, okay, in addition to our international commitment for non-proliferation, we also need to defend our national security and our national interest via the export controls or trade controls in a broad region. And in 2017, China introduced its draft on the export control law. It's a very significant progress in this area. Before that, we do have a number of legislation pertaining to export controls, actually dozens of them, but they are discrete from each other. It's very difficult for the trade community to follow up, to comply with, to implement. So this is a great initiative taken by Beijing, try to uniform all those scattered export control legislation into one thumb piece, which also try to utilize the control over dual use and the military or the defense areas together. Which inside you can find many similar concepts like export, deemed export, re-export, deemed re-export, etc. Okay, so that way I will want to let you know, after the draft, Beijing sent out information to the trade community and the world to collect comments on that. I know many companies, they have concerns like, for example, extraterritorial features in this draft. Because China, just like US, also asked the calculation of the de minimis but without giving the details how to calculate that. But we will control that. So this will be challenging if it is coming to reality for implementation. And just last year, China also introduced its criminal jurisdiction assistance law, which is focusing on the data privacy and protection, which states that foreign entities and Chinese entities, if you want to transmit data or information pertaining to criminal investigation or proceedings, you need to get permission first from the competent authorities. Otherwise, those information should stay on Chinese territory. You cannot let them out across the border. So all those information just reflecting that Beijing is rising up. They want to catch up with all the relevant aspects in terms of trade controls, in terms of export controls. Okay, this diagram for the professionals in export control, we are very familiar with it because in terms of export controls, we really focus on the 3 or the 4 dimensions. The person, we are talking about the screening list, the end users, and the product is about the items, the control list. For these 2 aspects, China also have the practice over there. For example, in the control list, China has its consolidated control list consisting of maybe 8 to 10 subgroups, and they will update it annually for the control list. So companies need to get them updated and stay current with those control lists. And regarding the purpose, the Ministry of Commerce, who is the competent authority in charge of export control in China, also require the end use and end use verification for the controlled items if you export them from China to outside. And in this regard, we also collaborate with U.S. government here to help do the end use verification inside China for the shipment export from U.S. to China as well. Okay. And regarding the place, the countries, China doesn't have country charts like US, but we generally follow the sanctions orders of the United Nations Security Council, that is UNSC, for all their sanctions on particular countries like North Korea, Iran. Chinese will follow and transform it into domestic legislation to asking for either the corporates or the financial institutions to comply with that. Okay. And in terms of controls on trade, I just want to give you an even broader view on that. Currently, China has more than 80 kinds of licenses, controls imposed on foreign trade. That is, if you conduct import or export, some of the licenses may hit you. For example, we have import license, which is generally stands for quota, controls on numbers of goods. But we also have the dual-use import license. We have controls on the precious metal like gold, silver for their export. We even have controls on endangered species, etc. So all these kind of controls, they have their own control list, and they keep updating, and they subject different license and licensing agencies in China. So how can you get yourself acquainted with those knowledge? So my suggestion is that don't get panicked, don't get anxious. It takes time to get yourself to become experienced. So today here, we just to kick off to have a start point rather than to end point. You don't expect to take all this knowledge and information, then next day you can work independently on all those issues. So this can be very complicated as an officer from the enforcement field can tell you. And here is the category of China's dual-use controls. As I show you, we have more than 40 kinds of controls. Here, just focusing one of them, the dual-use control. So in terms of dual-use control, we have another significant difference from US is that we control both import and export. So we call it trade control rather than just the export control. For example, if you import the controlled chemicals or radioactive isotope, then you need to apply from the Ministry of Commerce for the import dual-use license for that shipment. Okay. For the export side, we have similarly 10 categories, just like the CCL, similarly. But another very significant difference is that China doesn't have ECCN or neither use ECCN for its reference on the control. We use HS code, which stands for the harmonized system, okay? So that is a very important skill set you need to possess if you want to comply with China's dual use control, because you need to classify your products in terms of the harmonized system to get out its control code correctly. Okay, during the present made by the previous speakers, I heard a lot of questions regarding the regulatory bodies, that is the information about the agencies itself, because this is very important. You need to know which agency handles which businesses, or you may go to the wrong agency, just as the gentleman of making radar mentioned that he went to Malaysia Customs for dual use control list. That's a wrong, subject to talk with. So similar information for your guys is that in China, the competent authority in charge of the strategic control or export control is the Ministry of Commerce, okay? So they review the policy, they make the policy, they issue the license. And for China Customs is an enforcement agency who station themselves at the border to verify the licenses against the physical shipments. Say if your license states that you shipment some laptops, so they will open the container and the package to see if it is the laptops mentioned on the license and match the label, the models, the numbers, etc. All those kinds of information. So customs officers, they have the authority to challenge or make questions on your products if they doubt it is subject to actual control. Although you may think not, then who are you going to talk to? Don't argue with customs officers because they are just the agency for enforcement. You need to talk instead to the Ministry of Commerce. If the Commerce can give you a certificate or just a explanation, then you show this certificate or explanation to the customs officers. They will simply let the cargo go. So talk to the right person on the right subjects. This is very important, okay? Actually, to me, when I first time heard about that Singapore Customs you responsible for both the issuing the license, also the control, the cargoes, is also a surprise to me because according to Chinese culture, we think this power and responsibility should be divided to ensure sort of integrity. Just like in corporate, the cashier and account should be separated for two jobs, rather than you manipulate money and you make the records. But no, it's just a very frank feeling to share with you to tell that how diversified or how different the world can be. Different countries, different administrations, they may utilize different mechanisms to ensure the export control. So there's no one size fits all. But you guys as a corporate down to the ground, if you have your commercial presence or business operating in different regions, it's your responsibility or obligation to learn and to comply with those different legislations, okay? And finally, I just want to share some, challenges from the practice. Many speakers mentioned that as well, so I won't repeat it. I just want to present from a different angle or different perspective. I categorize them into three groups. The first is the framework and operation. So this part is the most essential and fundamental parts for companies who want to understand and comply with the strategic control. That is, you need to do the self-assessment whether you want to have an internal compliance program, whether you want to get into this business. So this is very fundamental, okay? And the second part is about the technical. Technical is that we will focus on or zooming on very specific topics which require further skill sets and knowledge on that. For example, taking the classification I've just mentioned. In China, you want to understand not only the HS classification, but also the ECCN classification. So how can you ensure your classification is accurate and in time. Because it's very challenging. For example, according to the HS classification rules, products can be classified according to their materials, structures, and also can be classified by the functionalities, by the end users. Sometimes those classifications can conflict with each other. For example, a general electronic devices maybe can classify as electronic devices. But if it is embedded into some function, like medical instruments, then it may be classified in the medical instruments. Okay. Another very frequent question or test I raise frequently is that, for example, bolts and nuts. Everybody knows that, right? We can find on our bicycles, in our cars. So if the bolts and nuts are used on a car and you going to import into Singapore, then what kind of HS code you would declare to the customs? Many people tend to declare them as car's components or parts. Yeah, according to the general populations, it sounds reasonable, right? Because those bolts and nuts will be used on my car. Why cannot claim them as the parts or components of cars? But actually, in the nomenclature, we have a dedicated subheadings for fasteners, for the metal products, where the bolts and nuts are clearly listed there. So this is a very common mistakes made by the importers and exporters on the ground. So I believe the same kind of situation will repeat itself in the ECCN classification, okay? And also with the trade patterns, some people may accidentally shipping something subject to controls to, for example, in Hong Kong. They have got a license in UK, but they forgot to apply for a license in Hong Kong. Once they dispatch the shipment, they find that the issue, so they send out a recall to the freight forwarders. So the freight forwarders stopped the ship in Hong Kong and under their control along the whole process, and then return it to the UK. So what does that mean in terms of Hong Kong's export control legislation? What kind of liabilities or obligations the shipper should have? So all those problems, issues, cases, they are very pertaining to the practical, our business model, our trade issue, etc. So how to apply the knowledge you learn from the legislation into your day-to-day operation is very challenging and very time-consuming. So lastly is about the crisis. That is when something bad happened. How are you going to respond it? Are you familiar with the self-disclosure of different jurisdictions? Do you have a special team that can be organized or assembled to respond in this crisis information? So sort of information just for your reference. Yeah. Due to the sake of time, I cannot expand on those points, but I'll be here later on ready for your questions or comments. With that, I'm going to end my presentation, and thank you for your time and attention. Thank you.
Johnny, thank you so much for that. Okay, ladies and gentlemen, we're down to our last presentation. So, let me bring back up Alex from BIS, one of my bosses. He's going to talk a little bit about sanctions. I'm going to give you roughly 14 minutes.
14 minutes?
Yes, and you're going to do this ad lib.
Yes. Oh.
So, yeah. So, good luck.
I'm going to do this ad lib. Okay, well, as Scott was saying, the presentations will be put on the Customs website. Since I'm not going to have my presentation up, I will ad lib, and Scott will put the hook on me if I go over. But I certainly want to give Alvin some time for closing remarks. There was a couple things that I wanted to talk about. One of them was our entity list. Scott talked about the multitude of variety of prescribed lists. We do have a consolidated prescribed list that was a result of our export control reform effort, a one-stop shop. The end-use review committee or end-use review process was implemented, I guess about 10 years ago. Traditionally, our entity list included entities or activities that were historically involved in WMD activity. About 10 years ago, we expanded the list to not just include those end users that we identified as WMD concerns, but we broadened the scope of folks that could be put on the entity list to include anyone that were involved in activities contrary to U.S. foreign policy, contrary to U.S. National security. The primary driving factor back then was uncontrolled components, non-controlled components ending up in improvised explosive devices in the Middle East that were traced back to U.S. suppliers. So as you might imagine, our entity list has grown over the years. But when we broadened the scope, we also created a review committee. So this end-use review committee is comprised of representatives from the Department of Energy, Department of State, and the Department of Commerce. And they meet periodically to consider activities that go on the list, as well as to consider and implement a process for those activities to get off the list. So that was one of the benefits of this process, creating an end-use review committee that would, by majority vote, put entities on the list. And if those entities were to appeal their being placed on these entity lists, a process where they could appeal and get off the list, getting off the list by unanimous vote of those agencies. If you keep up with our entity list, you know that, and this just one example to illustrate. A week ago, we published an entity list comprised of 28 entities involved in human rights violations in the Uyghur Xinjiang semi-autonomous region of China. We identified and placed 20 Security Bureau-related activities on the entity list, along with 8 commercial companies involved in essentially enabling those human rights violations. When we talk about our entity list, again, using this Uyghur entity list as an example, typically it's anything subject to the Export Administration Regulations, meaning those items that are EAR 99, those items that we control for anti-terrorism reasons, which can basically be exported from the United States generally without a license, are subject to a license requirement. Scott mentioned catch-all controls. Interestingly enough, a couple years ago when I was preparing for a catch-all presentation, you might find it interesting to know that the leading export license application for exports from the United States that were subject to a denial were those applications for EAR 99 items. Items that would typically go anywhere without a license from the United States. So what does that indicate? Well, one of the tools that we use to implement our catch-all is that entity list. The entity list, as Scott noted, is not a blacklist, but it's a list of entities that the United States has identified as either a foreign policy, a national security concern, a WMD concern that requires a license for typically everything subject to the Export Administration Regulations. And in some cases, those applications are approved, so it's not a blacklist. And in some cases, those applications are denied. So the End-Use Review Committee, there's a mechanism to get on, there's a mechanism to get off. I'm going to talk real briefly about sanctions. Corey mentioned sanctions in his earlier presentation in one of the opening panels. And typically, when we talk about sanctions, we're talking about a small group of countries. You know, when I talk about licensing requirements, I hate to use a pyramid as to illustrate, but you know, you have those items that are very sensitive and under the export administration regulations require a worldwide license. Some are statutorily required. For example, missile technology control regime items require a worldwide license if you're exporting those items from the United States. And rarely are there any general licenses or license exceptions. Now, when you get to the bottom of that pyramid, you have items that are readily available throughout the world, but there are certain foreign policy controls, entity list controls, where that large universe of items, including EAR 99, including items that are unilaterally controlled for anti-terrorism reasons, are controlled for export to a small group of countries. On one hand, I can count those countries. And those countries are the known problem countries in the world: Syria, Iran, North Korea, Sudan, and a country under a unilateral embargo, Cuba. So when you get to that broad universe of items, typically they'll require a license if you're going to export them from the United States to those countries. So that's about all I'm going to say about those 5 countries. If you're re-exporting to those countries, you really need to understand that if it is exported from the United States and is re-exported in the form received, it likely requires a license or some type of authorization from the United States. In some cases, OFAC, Department of Treasury, has jurisdiction. In other cases, the Department of Commerce has jurisdiction. Another thing to remember is that the de minimis calculation for those items that are re-exported that incorporate U.S. Origin components for those embargoed and sanctioned countries, that de minimis level in most cases is 10% by value. So another thing, you know, if you're incorporating some of those controlled items, and just as I said earlier, you really should just say no anyway. But if you're incorporating those U.S. Components, even at the non-controlled level, you need to be concerned about that 10% de minimis level. Other sanctions I was going to mention, certainly there's the Crimea, where everything's subject to the Export Administration regulations. Typically, it's a general policy of denial. There are some, depending on the country, someone mentioned safety of flight. That might be a factor. Medical, food, medicine, medical equipment, typically they require a license in some cases, but there's a more favorable licensing policy for things like that. The other catch-all I'd like to mention is our military catch-all. We currently have a military catch-all. All of this is in Part 744 of the Export Administration Regulations. But if there are certain items, and there's a supplement of the list of items that we have a concern about, are re-exported to Russia, China, or Venezuela. An exporter or a re-exporter has knowledge that those items are going to be used for military purposes, military end uses, or by military end users. That's a section of the Export Administration Regulations that you need to be concerned about if the item you're re-exporting is subject to the Export Administration Regulations. So I think that covers everything I was going to cover, and I think I got it done in less than 14 minutes. Are there any questions? All right, well, then I'm going to turn it back over to Scott.
Alvin, if you'll go ahead and come on up. As Alvin's coming up from Singapore Customs to close, first of all, I want to give our speakers and our presenters just an amazing round of applause. And I specifically want to point out both our Japanese colleagues that came down and Singapore Customs for being kind of the driving force behind a lot of this agenda. You guys gave us the information on your feedback forms, but it was the collaboration between the three governments that came together and got you what you asked for. Thank you for coming. And as the foot stomping that we've been doing, due diligence, due diligence, due diligence. I'm gonna let Alvin close and dismiss. Sir, thank you.
Thank you, Scott. You have been a wonderful MC for today. I hope this year's seminar has been useful in helping you to stay updated on the international developments and regulatory changes to the strategic trade control regimes across a total of 8 countries. Complying with export control regulations can be particularly complex as transactions involve multiple jurisdictions and in some situations, extraterritorial implications. Abiding by national regulations is necessary for businesses, and the failure to do so can be expensive, not just in terms of monetary penalties, but also reputational damages. Compliance is key, and the start to good self-compliance is awareness on the various requirements and control measures put in place for the goods and technology that your company manufacture or are handling as part of the supply chain. Keeping yourself updated on the international and national developments on strategic trade regulations will put you in a better position to operate within the boundaries of the law. Should you discover some areas of non-compliance, you should immediately contact your country's regulators, self-disclose the errors, and bring your company back to a position of compliance. As what Scott has shared with you, US also have the voluntary disclosure policy as well, our program. Same for Singapore. Proliferators often use front companies to mask the actual end user and destination. So please take note of the red flag indicators shared by a few speakers today. Compliance is end-to-end. For companies who diligently institute a strict internal compliance program, it will be a waste to end it all when the goods leave your warehouse. In fact, it is when your goods are transported that the real compliance is realized. Your appointed declaring agents and freight forwarders are the actual parties who can ensure that your goods are delivered to your customers. Hence, it is necessary for you to make sure that your declaring agents and freight forwarders also comply with the regulations. And for intermediary ports like Singapore, please take note of our transshipment and transit requirements and regulations. We would like to express our sincere thanks to NEC, DSM, Rockwell Automation for sharing with us how you implement your internal compliance program, and our sincere appreciation to the expert speakers from Australia, China, Japan, Malaysia, Philippines, Thailand, and the USA. A big thank you to our co-organizers and sponsors from the US BIS, US EXBS, Japan MITI, and all the helpers who make this seminar possible, including my colleagues from Singapore Customs. Thank you everyone for your participation, and I wish you a pleasant evening, and to our foreign guests, a safe journey home. Thank you.